Hello, folks, and welcome to another chapter, a lesson. So, forgive me, the last video that I said this is the last chapter. I apologize. This is not the last chapter. This is the second last chapter. There's another chapter, chapter 13, and yeah, this is not the last chapter. I apologize for that. And this chapter, we are going to learn about alternate dispute resolution. So in we call it ADR, and this ADR you can just simply look at figure it out. Um, what's the meaning of this topic as well? So so that means finding alternate means finding other ways resoluting your disputes. So what are the other ways? Finding resolving our dispute. Mainly people know it's court, but it's not the court. Court is the ultimate, the back end solution, but there are others. You can, solve your problems, your issues before going to the courts, because going to the court is expensive, and this ADR method is much more cheaper, and it's more easier uh, to to resolve disputes, and it takes much more short time rather than the courts, which takes a longer time. So what are these OADRs? So mainly it's two types. It's mediation and arbitration. Sometimes this mediation and arbitration cost a bit more, but it's the process is far more shorter than the courts. So let's get into it. What are these mediation and arbitration? Ah, so we got, yeah, alternative dispute resolution. So this litigation is a process where opposing parties to dispute to assume positions to enforce or defend a legal right in a court of law, presided over by a judge who gives a verdict on the rights and liabilities of a disputants. ADR process, references ADR, dispute resolution process are these things. So ADR is a collection of process used for the purpose of resolving conflicts or disputes informally and confidentially. ADR refers to a variety of processes that help parties to resolve disputes without a trial. Um, a dispute resolution of seeks that limit the cost of litigation by using an alternative, often out of court means such as arbitration, conciliation, and summary possessions proceeding. SPP, we call it that. ADR is termed that there are several different methods of resolving disputes outside traditional legal and administrative forums. So you can get a clear picture and idea, overview of the ADR. So yeah, the importance doesn't require a great deal of time. Like I said before, hearing cases, is easy. The ease of duties, such a not a complex process like in the courts. Uh, Amicable settlements motivated by main between parties. So parties can express their views without strict restrictions in observed in the courts. Less formality in procedure. People do not have a strict knowledge about the procedures and law. Merits of ADR. So save time, save money, put parties in control, focus on the issue. Yes. So as pretty much a legal professional, we go for these mediation and arbitrations as well. It's quite simple. It's quite easy. Things you just have to sort it out, and so on. It's flexible and creative. Both parties can be in creative way, but there is person at the end of the day. In some areas they can mention things down, both parties were talking about. Yeah, preserve relationships. So if we go for these ADR things, rather than going to courts, for in the courts, people are between parties are really angry each other. They hate each other, but they try to solve it in the civil manner, in a civilized manner, I would say. But in the ADR, if you go for this, they both parties can talk. They can, resolve their issues, and they still can have a good relationship. Uh, Reduce obviously stress. Uh, Being in courts, it's pretty much takes the whole day, So try not to go to courts. Try to resolve this to ADR. So keep private disputes private, because if things goes to courts, unless except rape cases, these disputes, to courts, disputes goes to the public. Anyone can free to see the law books about relevant cases regarding any person or for company. It's pretty much open to the public. That's how it is. uh, be satisfying to the participant, give more people access to justice. So being in courts, I would say, is a complex procedure, and not anyone can go inside the courts. Only the parties who have been agreed to, especially normally, during harsh times, they will be obviously, people will be in rigorous checkings. And when they for checkings, because to prevent overcrowding inside courts, so therefore they will be subject to stay outside. But normally, access to justice, no one can, not anyone has the ability to go to courts, but through ADR, everyone can go and resolve their disputes. So demerits means disadvantages. Anything, anyway, you have disadvantages in any system. So sometimes say, wastage of money if the money is not resolved through them. Limited judicial review, of course, because there are no judges. There's some sort of a panel of board who will be there, with have a certain amount of knowledge, but I wouldn't say they have a knowledge of a court judge. Informal, more opportunity for abuse of power, that's there. Normally, sometimes, if the panel is corrupt, I would say they would obviously get bribed and things like that. But normally, it's quite informal. Anyone can come and talk to each other, and so sometimes the parties who are involved in can abuse their power. They will start yelling each other, at each other. So because I'm speaking from my own experience, sometimes these ADR, this or disputes, they don't matter in the courts. They sometimes yell at each other. They fight it at each other, because rather than just resolving disputes in a friendly manner. So yeah, that's the unfamiliarity with the procedure and lack of awareness. So normally, exactly, courts, they, because there's a law in the courts, but in there, they just like put on their anger. They don't know what is a formality. They don't know what it is, because mostly people who doesn't know what ADR is, they have no idea about the simple procedures. So parties may have limited bargaining ability. Yes, that is there. Disclosure of information and truthfulness of communication depends on good faith. Parties can be used as a stalling tactic. Yeah, it can be like that, because sometimes when you go for mediation and arbitration, the person who made a fraud, who commit a fraud, um, can can drag time. Because okay, I will give you, I will have this, things have this. So we have this stalling tactics until the defendant disappear, or they will find a collective man, rather than going for a liquidation in the courts, because it will be much more quicker than then. But at the end of the day, courts is a complex system, and it takes uh, ridiculously amount of time. And these are the types of ADR: arbitration, mediation, and conciliation. So um, arbitration and mediation conciliation are the main methods, and so there are two ADR mechanisms which are recognized by law: arbitration and mediation. Conciliation, um, not many people use it, but arbitration and mediation are the main two methods of ADR. Yeah, let's get into mediation. So, in mediation, it's an attempt to bring peaceful settlement or compromise between disputants through intervention of a neutral party. So, this activation of third party mediator is who works to find points of an agreement to make those conflicts in agree on a fair results. So it is a process used to intervene between two or more disputants in order to bring about an agreement, a settlement, or a compromise. Mediation is an informal dispute settlement process run by a trained third party called mediator. So, mediation is an adversarial process which is managed by a third party. So the mediator reach a settlement is one acceptable to them. Mediator does not intervene proactively in the dispute resolution process, takes sides of a judgment and give directions to the parties. So the mediation contract normally complies with certain principles. These principles are specific mediation process as opposed to the other dispute resolution process such as arbitration and conciliation. Mediation is a confidential process. Every party to a dispute, every mediator is duty bound to maintain confidentiality with regard to documents submitted during the mediation process. And all this, so no statement made by any person at a mediation session is admissible in evidence in civil or criminal proceedings. So we are parties to a dispute agreement. So to a settlement terms of a settlement form binding agreement between the parties and is enforceable in law as a valid contract. Procedures of a mediation: the mediator will let two parties introduce themselves and explain their current position. The mediator will listen to them separately. The mediator consider individual facts that identify weakness between parties in the contract and try to help the disputants solve their cases without stepping into the litigation actions. After the process, mediators will listen to options which are presented by both parties. If the parties reach a settlement, an agreement will be signed. If it is violated, it is considered a breach of contract. If no settlement is made, case will proceed to a litigation in court. So what are the so this is the legislative body, Mediation Board Act number 72 of 1988. So it has been amended from in 1997, 2011, 2016. So latest is 2016. So we have another act for mediation special categories of disputes, 2003, and Commercial Mediation Center for Sri Lanka Act, 2000. So Mediation Board Act number 72. So the main act. So the legal framework institutionalizing mediation to resolve process of mediation. So referred by dispute parties. It's an instance of courts. So mediation board commission. So it's they're the one who are appointing mediators, also vested in the power of dismissal and disciplinary courts, mediates and supervising, controlling performance, discharge, and function duties of the mediator. Mediation types of enforced by the courts. So commercial mediation, it's commercial. It's done by Commercial Mediation Center Act number 44 of 2000. So this to established in September 12th. So it's further it was amended and effective from the Ministry of Justice in 2017. Community mediation. So this provides mediation boards to process received any certain instances by courts. So normally in mediation, sometimes the mediator will be a qualified lawyer, or someone has followed mediator courses in the commission. So normally the lawyer is pretty much a qualified legal professional. So in that case, they do not actively involve like in courts does. In courts, a lawyer does the talking. Sometimes parties who involve bringing to the witness box and ask certain types of questions to resolve it, but the mediator is pretty much silent. They do a minimum amount of talking. They let the parties decide to talk, and they will note down any weaknesses and strength there, and they will combine, and they will come. They are the one. Mediator is the one who comes to. They will give the options between two parties, certain types of options. If they are not happy with the options, let's say the option number one not happy with the party A, and the option number B this not it's not happy, the party B is not happy. So what happens, this since there's no resolution uh, at the end, so the mediator will say, okay, uh, the time frame for the mediation is done, is enough. um, so so therefore, if there's no resolve for this matter, just take it to the courts. The court will decide it. Arbitration, yes. So arbitration is quite similar to court hearing. Dispute parties are present, commonly accompanied by their lawyers, and dispute is determined by an impartial arbitrator who may court appointed. The benefit of using arbitration is that it is cheaper, and the rules of arbitration are not rigid as the rules of court. So Black's Law Dictionary. This is one of the most crucial books in the legal field. Black's Law Dictionary. It has been written quite some years ago by a prominent lawyer and a judge in UK. So it's interesting. So there are certain um, definitions for arbitration. So in Dictionary of Law, it's from Oxford. So in American, what you call these heritage of dictionary, American dictionaries, so Britannica, they have different types of what you call definitions has been given for arbitration. So normally, yes, in 1995, Sri Lanka enacted Arbitration Act number 11 of 1995. So this is a legislative body. So there are centers that have been established facilitate conduct arbitration in compliance with the rules as so centers. Uh, yes, so according to the principle, the Convention on Recognition and Enforcement of Foreign Awards, 1959, so the New York Convention made comprehensive legal provision to conduct arbitration. That's how it is. So the act is very large follows uncitral. That's how obviously spell it for uncitral model law. At the same time, certain departures from additional rules given to the model law have been made. Arbitration agreement and court proceedings. Yes. So this act provides arbitration. It can be contained signing documents, exchanging letters, telegrams, any other means of communication which provide a record of agreement. Act provides by any dispute can be determined by arbitration unless the matter in respect of which the arbitration agreement is entered into is contrary to public policy or is not capable of determination or by arbitration. If legal proceedings are instituted in courts, what you call by parties uh, covered in an arbitration by the agreement, court shall have no jurisdiction to hear, determine the same party of them. So these are the sections has been given by the act. So composition of arbitral tribunal. So parties are free to determine the number of arbitrators, but if it's even number, then the arbitrator was appointed shall appointed an additional arbitrator who shall act as a chairman, where the parties do not determine the number shall be 3. So yes, uh, The parties are free to agree on the procedure of appointment. Failing such agreement, it takes to the High Court. Uh, if the agreed procedure fails, then also High Court has the power to make the appointment. So powers of the tribunal to rule on jurisdiction, to decide all procedures and evidential matters, to appoint expert legal advisors and assessors, order security for cost, director of a witness to examine on oath or affirmation, to make provisional orders, to order payment of a sum of money, to order party to refrain from doing something. Termination of a mandate of an arbitrator terminates if the arbitrator becomes unable to perform his function for any other reasons, to fail to act without due delay, or dies, to withdraw from the office. If the parties agree on the termination, it may be noted that the provision of terminating a mandate by the agreement is not found in many arbitration acts. In case of undue delay of an arbitrator, is aggrieved party move the High Court to remove him and to appoint another person in his place. So, how you challenge an arbitrator according to Section 10? Arbitrator disclose circumstances raising justifiable doubts to his impartiality or independence. If circumstances exist which give rise to such doubt, a party may challenge the arbitrator. If the arbitrator does not resign, the matter can be taken to the High Court. Challenges to the jurisdiction. So the so if arbitrator appointment can be challenged, you can be appoint challenge to the jurisdiction as well. So you can apply for the High Court for determining such questions. Interim measures. So interim measures provide an arbitrator provide settlements. So it can be for mediation, conciliation, or any other procedure. So arbitration proceedings or many other things. So normally, when going for an arbitration, normally it has to be an odd number. If there's an even number, it should be, so so arbitration will not proceed. So as one will be acting as a chairman, the others two will be the arbitrators. So their vote is quite necessary in order to proceed with the some sort of agreement that the both parties have reached. So it is an alternative has given that okay, so who challenged, who said yes, who said no, and it will be passed. But if they're not happy, the High Court will appoint a certain amount of things in order to achieve a proper arbitration. Normally these things happen due to frauds, normally high purchase disputes, money recoveries, things like that. That's how it is. So normally specific performance duties also applied in these cases regarding mainly for departments and for ministries. Arbitrators, so normally that's how it is. It's quite simple. Can be keep it as a confidentiality, and the arbitrator is normally known as a both parties can bring lawyers. You don't have to bring a lawyer if you want, but the lawyer will be silent most of the time. They will be just guiding through what to say and what to say not, and the parties, there's the one who talks a lot. No, the arbitrator gives some resolute and things like that. Yes, you don't have to bring a lawyer, but it is better to bring a lawyer, because if you don't, the other party may bring a lawyer. Yes, so duties of an arbitrator. So must deal with dispute impartial and practical, expeditious manner. He must afford the opportunity to present respective cases for examining all documents and other materials furnished by the other party or by any other person. Proceedings to appear before it or to comply with any order made it by its section. Uh, so interesting, useful point with Sri Lankan Arbitration Act relates to amendment of pleadings and relation to the relief. Parties are allowed to introduce new prayers for release. Such prayers fall within the scope of arbitration agreement. It is not appropriate accepting them, having regard to the point of time which the new prayers are submitted in other circumstances. Parties are allowed to amend, supplement of the prayers of reliefs are already introduced. rely on new circumstances in support of their respective cases. Yeah, so the venue, parties may determine the venue of the arbitration. Failing agreement, the arbitrator decides having regard to circumstances of the cases, including convention of the parties. But normally, arbitral tribunal may meet any place considered appropriate for consultation among members, hearing, witness, inspection, and so on. Yes, so the both parties has to bear the cost of the venue where the arbitration happens. Uh, Normally, they cannot have arbitration venue in their own respective places. Has to be a some sort of a meeting place. It can be a hotel, it can be a convention room, it can be a small room, or it can be a normally what companies and people does, they will have it in what you call this municipal council halls. They have certain halls as in the these function halls. They appoint some such places, and they sit down and they talk. That's how it is. So procedure generally including evidence. So in section 17 it says that decisions shall be made by majority of the arbitrators. Yes, such as voting, and the voting has to be the voters has to be in odd numbers. Failing a majority decision of the arbitrator appointed by the other arbitrator shall be binding when in terms of the agreement of the or the act there is a chairman, and then the decision of a chairman shall be in binding. Where there is a chairman, he or she has the power to administer the conduct of arbitral proceedings. So summon of oaths. So let me so in decisions, normally there's two arbitrators, or it can be three or five. Mainly it's three if it's like a normal simple case. If it's like a huge disputes of arbitration, it can go up to five, sometimes 11, things like that. But normally 3 and 5 is the main thing. So says there's a one chairman, so if there's a even what you call vote for between both things, the chairman will decide which side or which proposal that they have to be agreed upon. So the chairman does not vote unless if there is an even vote. So his or her vote will be counted at the end. So whatever his vote will be pretty much in the winning side if the vote is even. Uh, so summon of oath. Party may be witness rare writing written consent of the arbitral tribunal applied to the High Court for summons to witness. Yeah, summon of oath. So that means you just sending summons by through the courts. So the courts will goes through. You just stamping and give into the what you call through post, sending as a registered post to any particular person or place to come for an arbitration. So within pretty much 14 days, so there's reply a letter of demand. So within that demand, so you have to 14 days you have to um, you know send a reply saying okay, we will be there at what time, decide the venue, and then the letter will be get exchanged. So once they are ready for the arbitration and they have decided the venue, they will become. So summon of oath, that's how it is. So penalties provided for failure to attend or refusal to take oath. Exactly. So if you refuse to send a reply, or if you just give like a Nokia attitude, there will be a penalty. It will go at ex party. That means one party will be negotiating. If the other party is not attended, the party who has attended has far more advantage of in the negotiation table. So so it may be mentioned that the arbitrator is expressly empowered to administer oath unless otherwise agreed upon the parties. The oath is not provided in the Indian Act, but through it was provided in the Act number 1940. So yes, so so everything is covered. Evidences. So the Act contains two important provisions regarding evidences before arbitral. So under so unless otherwise agreed upon, the parties um, before the arbitral tribunal may be given orally in writing by affidavit. This provision may seem to be confer discretion on all concerned. Otherwise, the according to the evidence ordinance, arbitration pretty much is not binding. They can providence, but they don't have to like in the courts does. Representation of the parties, it can be personally available. Parties of the body of a corporation through an attorney at law, if the parties are so desires. Exactly, a lawyer he can be can not come. It's not necessary like in the courts does, but I highly recommend to come with an attorney who has experience in arbitration. Applicable law, most arbitration acts usually allow the parties to choose the substantive law to be applied if it is a transactional contract. The act goes a little further. The material part of the section 24.1 provides under an arbitral contributor tribunal shall decide the dispute in accordance with such rules of law chosen by the parties as applicable to the substance of the dispute. So here there is no limitation to main should have foreign elements. Thus, even to agreement between two Sri Lankan residents, companies can choose foreign law of companies where provisions only applies only to extent agreed to the parties. So section 24 2 says that these are some provisions. Whoever says that apply only to the extent agreed by the parties, but if the parties does not agree, the provisions will be null and void. The question naturally arises that where the outcome if the parties neither have chosen a particular system of substantive law, conflict of rules appear. The arbitrator will apply the rules of conflict of laws would be reasonable cause to adopt in circumstances. So compensation of arbitrators that contains specific provision as to compensation for arbitrators to the effect that parties shall be jointly and severally liable for the payment, a reasonable compensation to the arbitrators constituting of arbitral tribunal for their work and disbursement. So the act does not give like a certain money, so it depends on the arbitrators who actually agreed upon some sort of monetary value per day. It can be per day or pretty much per throughout the whole arbitration process. So there's no saving regarding any provision in this agreement. To the contrary, the details are provision as to deposit, etc. So normally they have to deposit the money, they have to show the bank slip, and after that the arbitration happens. If the if there's no monetary value, so things like that, it depends on the arbitrators. So yes, award. Award is to be made writing and signed by the arbitrator. The majority may sign the give reasons for omitted of signatures. Reason must be stated. Subject of the provision is act final with the binding of the parties. The award is pretty much the final decision has been given. Correction and interpretation act provides that the interpretation shall be awarded as for the modification in the case of omitted matters. Certain time limits are provided for in this regard. And enforcement of the award. The award can be enforced by the High Court on applicable made to the High Court within 1 year and after the expiry of 14 days, making the award. So yes, they can appeal after 1 year of expiration of 14 days. So subject to the provision regarding setting aside of the award, High Court shall on a day of notified to the parties proceeded to file the award and give judgment according to the award. Upon the judgment, so decree shall be entered. Thus, the intervention seems to be decree, so enter shall be executed like any other decree of a civil court. Setting aside the award. The award can be set aside by the court on the grounds which are substantially similar to those laid down in the ancestral mode of laws. So they can set aside an award within with the application within maybe 60 days, no less. If you can do that, you can set aside the award and can move forward. And it depends on the both parties who have been agreed upon in their private discussions too. And that's all. Pretty much end of the chapter 12 ADR, and then I'll definitely see you in the chapter 13, which is the last chapter for business for BL3. Okay, thank you.